Welcome everyone to this webinar about protest law. My name is Samantha Lee. I'm the Assistant Principal with Redfern Legal Centre. I'd like to acknowledge people, First Nations people. I'm on Gadigal land in Sydney of the Eora Nation. Protesting has a long history in Australia, and we cannot forget First Nations people and how they have protested, particularly around land rights and voting rights and many other issues in Australia. This webinar is being recorded, so if you don't want to be recorded in terms of your questions and answers, then please keep that in mind when you are lodging a question here. We will be taking questions at the end, around maybe 5 minutes before the end of the webinar, which is around 1 p.m. You can lodge your questions in the questions and answer, which will be anonymous, or the chat will not be anonymous. There is a message in the chat room about questions and answers. I'd like to introduce Rian Terrell, who is a solicitor at Redfern Legal Centre in our policing and accountability and generalist legal team. He has worked at Kingsford Legal Centre and Australian Government Solicitors in admin law and litigation. He was also the tipster for Baston judge, and I'd like to say his case law is impressive and he's able to dissect cases in no time at all. Just to introduce you to this webinar, which is about protesting law. Protesting is an essential part of democracy. It's a form of government accountability, particularly for marginalised groups. Democracy takes place for not just left groups, but also groups from the right, and that's why it is a form of accountability. In Australia, democracy has spanned many different voices from land rights to women's rights, First Nations and environment. There have been moves to curtail the right to protest here in Australia, which Ryan will go into and look at the history and recent casework in the development of trying to curtail protesting here in Australia. I'll just leave you with a Harvard research, which is about the 3.5% rule, if anyone has heard of that. Two professors from Harvard University looked at databases of civil resistance campaigns from 1900 to 2006. They analysed whether non-violent or violent movements were more likely to succeed and whether there was a tipping point in terms of size for protests to actually expel the party or persons in power. What they found is that non-violent campaigns were often much larger and were twice as likely to succeed than violent movements. They were more representative of populations, and they found active and sustained participation by 3.5% of the population meant a movement would succeed with very few specific exceptions. Now I'll hand it over to Ryan to commence the webinar.
Thank you, Sam, for that introduction, and thank you for being here today, everyone, and also just wish to acknowledge that I am presenting from Gadigal land. We're going to cover a few topics today. Obviously, this is a discussion about the law, but it would be remiss of us not to situate protest law in a little bit of context. So just to give a quick outline of the discussion today, we're going to be starting with some history and context. Obviously, that's a large topic and we have limited time, so we've just picked some highlights that we think are important for you to know. We're then going to talk about the sort of the history of protest laws in New South Wales, as well as the current legal situation. We're also going to spend a bit of time talking about the police, because we think that's a particularly important thing to talk about when we talk about protest rights. And we're also going to talk about other developments in the law, so other laws that have been used in recent times to regulate or to restrict the right to protest in New South Wales. Um, as Sam indicated, protesting is obviously a fundamental part of Australia's democracy. The Australian Constitution protects political communication through an implied limitation on legislative and executive power, which we'll be discussing. However, it's important to note that the Australian Constitution does not confer a personal right to protest or to free speech, as, for example, the First Amendment does in the United States. Um, Australian parliaments and governments also have some latitude to put limits and restrictions on protest rights. And we're going to be exploring some of those in this presentation. We're also going to provide our views about occasions recently where we think New South Wales has fallen short in protecting peaceful assembly and protest. It would also be remiss of us not to mention that we support the introduction of a Human Rights Act in New South Wales to protect human rights, including an individual right to free speech. We know that there's currently a private members' bill before the Legislative Assembly, a human rights bill, which we as a centre support and is relevant to this discussion as a whole. So just to reiterate some contextual sort of uh, understandings. In Australia, there is no absolute right to free speech. Governments and parliaments are ultimately responsible for passing and enforcing laws that govern protests, which are often directed against them. So this does give rise to a situation in which the government is sort of the fox guarding the henhouse and controlling or regulating protests that may well be directed against them. Governments can and parliaments can limit protests to some degree, especially for safety or public order reasons. But we've also seen governments in recent times limit protests for other reasons, including a desire to stop certain types of protests or to shut down certain types of political communication. The other contextual feature to note is that there are laws in place in New South Wales that regulate the holding of protests. And this involves, in broad terms, a process of notifying the police of the intention to hold a protest and the potential to go to court if organisers are unable to agree on the holding of the protest with the police. So we're going to talk about that in a little bit of detail. And also just contextually, when we talk about protest in this presentation, we're generally talking about peaceful protests that involve political issues. When we use the word political, we mean it in its widest possible sense, including in relation to the actions of governments or social issues between people. When we talk about protests, we generally are referring as lawyers to peaceful, non-violent protests. We're not referring to necessarily to actions such as civil disobedience or things that involve deliberately unlawful conduct. That's not to say, though, that those actions do not involve the expression of a political opinion or a political or protest in nature. But it's just to note that any sort of protest that involves, for example, violence or a threat to public safety is less likely to enjoy constitutional protection. Um, so we also just wanted to briefly note, again, it's impossible to sort of summarize everything that's happened in protests in New South Wales, but there's a rich history of protests in New South Wales. People in New South Wales have protested since the invasion and colonisation of Australia, whether that's through resistance by First Nations peoples against colonisation, to convict demonstrations against authoritarian martial law, to movements throughout the 20th century for civil rights, as well as modern protests. We would say that protest has been and will always be a fundamental part of a functioning democracy, and has also resulted in many changes to the law and the advancement of civil rights. Examples of protest movements in Australian history have included the workers' rights marches and the resulting 8-hour workday, civil rights protests, for example, the Freedom Ride in 1965, a trip through New South Wales for the promotion of Indigenous rights. The Mardi Gras protest in 1978, which infamously also involved significant police brutality. as well as a healthy and sustained anti-war movement, which we see particularly starting with the Vietnam War, through to more recent protests against the Iraq War and also in relation to conflicts in the Middle East. Um, Throughout this presentation, we're obviously going to be proceeding on the assumption that protest is a good thing and an important way in which we can express ourselves, and it's also important to Australia's functioning as a democracy. In this context, it's also important to note that protest and democratic expression is also protected by international law. Um, when we talk about international law, we are talking about the laws that applies to the actions of states and state actors as between states. International law protects many human rights, and this is just one of them. Australia has ratified the International Covenant on Civil and Political Rights, which contains various protections, including Article 21, which contains a protection for peaceful assembly. The text of Article 21 is on the slide, and you can see that it recognises the right of peaceful assembly and says no restrictions shall be imposed on the exercise of this right other than those that are in conformity with the law and which are necessary in a democratic society in the interests of national security or public safety, public order, the protection of public health or morals, or the protection of the rights and freedoms of others. We obviously don't have time to go through Article 21 in detail today, but we just wanted to note that Australia is a party to this treaty, which does recognise peaceful assembly, and it also says that to the extent that that right is limited, it has to follow one of those nominated exceptions in the article. And international law is also clear that the extent to which a state can rely on those exceptions to limit process is also limited. So even if a government can actually show that an exception applies and that restrictions can be imposed on the right to peaceful assembly, the extent to which those restrictions can be imposed is also limited to only what is reasonably necessary and proportionate. Although, as a member state, Australia is bound by the ICCPR, the ICCPR has not been fully incorporated into Australian domestic law. So it's not directly binding on Australian citizens or on the Australian government, except to the extent to which it has been implemented in Australian law. Despite that, and despite the fact that the ICCPR doesn't form a part of New South Wales law directly, we still say it's an important contextual consideration in assessing the democratic legitimacy of laws in New South Wales and in Australia. And it's a way for us to it's a tool that we can use to analyse laws that have been passed in Australia. We say that, or we will say in this presentation, that we think in a few different respects, laws in New South Wales have recently failed to comply with Article 21, and we think that if Article 21 was directly a part of New South Wales law, there would be some serious compatibility issues. Also in this again, some more context, the Australian Constitution, although there's no individual right to free speech or related rights, it does protect the implied right to political communication. It doesn't do so in the, I don't know if you can see, but this is the Constitution. It doesn't do so in the literal words of the Constitution, but instead, in a series of High Court cases from the 1990s, judges have read into the Constitution basically an implied freedom of political communication, which rests on the idea that Australia's constitutional democracy, its legal framework, cannot function without a freedom to communicate on political matters. In particular, we as Australians cannot have fair elections. We can't choose our members of parliament without some latitude and freedom to communicate on political matters. The implied freedom of political communication protects Australians from laws that disproportionately interfere with our ability to talk freely about politics and government. And it covers political communication on a wide range of things, including things like communications about elections, such as campaigning, protesting or debating, criticism of members of parliament or of the government of the day, talking about government decisions or laws, and also talking about political issues in the widest possible sense of the term. All of that is to say that Australian parliaments and governments can restrict political communication, but only if that restriction is for a legitimate purpose and the restriction is proportionate to achieving that legitimate purpose. So, one way of thinking about that is that the law doesn't go further than what is necessary and suitable and adequate to achieve that legitimate purpose. I've got on the slide a summary of the questions the courts tend to ask when these cases come up in applying the implied freedom. Um, and if a government or a parliament does something which doesn't comply with the implied freedom, then the law can be invalidated or struck down. Um, and we're going to give some examples of that in a little bit of detail shortly. But there have been a number of examples of Australian courts invalidating legislation and government acts that infringe the implied freedom, including attempts by the Tasmanian government to criminalise protests on forestry land in Tasmania, attempts to restrict or regulate campaign funding of politicians, laws at major facilities in New South Wales that penalised causing serious obstruction to major facilities like roads or a port, where the offences were too broad and vague in their description and disproportionate to the purpose being pursued of securing the ports. And also, most recently in New South Wales, the Public Assembly Restriction Declaration, which stopped public assemblies from happening for a period after December 2025, which we'll be talking about in a little bit of detail later in this presentation. Just pausing with one final observation about the implied freedom. Peaceful protests or protests may fall within the freedom where it communicates on governmental or political matters, but not necessarily everything that is done at a protest is necessarily going to be protected by the implied freedom. There is some elasticity there, and it requires assessment on a case-by-case basis. Again, just to speed through some brief history, this is very important for the conversation we're about to have. A very important part of the history of protest laws began with the Summary Offences Act 1970 in New South Wales, which was introduced in the context of large-scale, continuous and highly visible protest movements in Australia against the Vietnam War and the moratorium marches. Those marches were involved at one stage over 200,000 participants nationally and were the largest by scale protests in Australian history at the time. The anti-Vietnam War protesters and student activists were strongly denigrated by the politicians and government leaders of the day, and that was the context in which that legislation was passed in 1970. The 1970s legislation was very restrictive as it required organisers to obtain permission from the police for certain processional assemblies in public places to proceed. This legislation was seen as going too far in restricting protest, and in 1979, the government of the day replaced it with a different scheme, which it repealed a sort of a permission-focused or a permit-based scheme to a police notification scheme, where organisers would let the police know that a protest is planned and that a court could become involved in cases of disagreement where the protesters and the police can't agree on the proposed protest. This 1979 legislation forms the basis for the 1988 Summary Offences Act, which is sets out the current notification and Form 1 scheme, which I'm now going to talk about in some detail. So the Summary Offences Act is what contains what is called the Form 1 procedure. The Summary Offences Act regulates a lot of different things, including behaviour in public places, but it also regulates public assemblies through the Form 1 procedure. The current law is often referred to as the Form 1 procedure by shorthand. If you want to hold a protest or a public assembly in New South Wales, it's a good idea to do this process, which involves essentially filling out a form and notifying the police commissioner of the details of the proposed protest. And we're going to spend some time today discussing the Form 1 procedure, as that's the most important law to sort of understand if you want to understand protest law in New South Wales. Before we talk about the Form 1, you might be asking, well, what's the point of notifying the police and the government that I'm proposing to hold a protest? Why would I do that? Or perhaps why do I have to do that? I can't necessarily answer all of those questions, but I can tell you that if you do wish to hold a protest and you do participate in the Form 1 process and it's approved through the Form 1 process, you do get the benefit of this fairly important provision in the Summary Offences Act. It's a long provision, but essentially what this section does is that it provides immunity for people who participate in a authorized public assembly. And it provides immunity for certain, in particular, for certain traffic obstruction, pedestrian vehicle, vessel obstruction offences that apply in a public place, where obviously where the authorized assembly is held in accordance with the Form 1. So, for example, if you're hoping to organize a protest that involves movement, so it involves moving from one place to another, for example, from Hyde Park to Central Station in Sydney, that involves you moving on paths and roads. It's impossible for the procession to occur without that happening. And if you have a lot of people coming, there's a chance that it's not possible to safely do that on the footpaths. The roads might need to be closed. And if you don't have an approved authorization in place, it's possible that everyone who is, blocking or obstructing a footpath or a road could be charged with an offence under the Summary Offences Act. But what this provision does is it removes that possibility for people that are participating in an approved public assembly and are obstructing a road or a path. So the Form 1 is a very important document to fill out because it provides participants with that immunity, and it also lets the police know ahead of time what the protest will involve and affects the policing response to the protest. The Form 1 document is available online on the police website, and if you're organising a protest, it's very important that you carefully fill out that form with very accurate information and give all the required particulars. The particulars that you give will be very important because that will affect the consultation process with the police commissioner and any arrangements that the police might need to put in place, for example, closing public roads or taking measures to do what they say is promoting public safety. Again, just to reiterate, if the Form 1 is approved either directly by the police or by a court order, people or participants in the protest or the public assembly will have the benefit of that immunity from blocking traffic or for marching on a road. So in that sense, the Form 1 process facilitates public assemblies and protests because it allows people to attend them in public places without fear of being charged with minor traffic or other offences. The essential sort of parts of the Form 1 processes follows. The first is to note the time, day, and location of the protest. Organisers in doing so are going to have to think about where it should be, where it will end and disperse. There might be a particular place they want to go, for example, Parliament House, because of its significance as the seat of Parliament. But it's important that the organisers have a concrete idea of where the protest will take place. If it's going to be a moving protest, where it will start, where it will end and disperse. The type of land that's going to be involved. For example, will it only take place on public land, or is it going to take place on mixed private and public land? For example, certain shopping malls, they might appear to be public land, but they are privately owned with a public right of access. Public land can also be regulated in different ways. For example, the Sydney Opera House forecourt in New South Wales is regulated by bylaws and by regulations. So there's a number of sort of considerations that are going to have to be considered by protest organisers when deciding where the protest should take place. They'll also have to note in the Form 1 the purpose of the assembly, the number of expected participants, and details of the organizer and an acceptance by the organizer for the responsibility of the conduct of the assembly. So there's quite a lot of information that needs to be provided up front. The other very important thing to note is timing. Um, so unfortunately, the Summary Offences Act procedure disadvantages what are commonly referred to as snap rallies or urgent rallies that are sort of done immediately or urgently without planning, because the Act sort of conceives of an orderly process occurring in which the police and the organisers spend some time potentially negotiating or discussing the assembly, and if that fails, going to court. If you submit the form less than 7 days before the assembly, um, and the police don't agree to you holding the assembly, they say that they're not in a position to authorize the assembly. Um, if you want the assembly to become authorized, you must apply to the court, to a court, or normally the Supreme Court, to authorize the holding of that public assembly. So the benefit of submitting the form 7 or more days ahead of the proposed public assembly is that if the police don't agree to the holding of the assembly, then it's the police that are required to apply to the court, and they are the ones that must make that application to prohibit it. And if they don't obtain a court order prohibiting the assembly, then the public assembly can proceed as authorized. So there is a strategic benefit to applying to and submitting this Form 1 document 7 or more days ahead of the proposed assembly. And there's significant benefit to doing so. The main change being that the court process will differ depending on the timing, as I've just explained. So if you and the police can't agree to the holding of assembly, for example, the police tell you that you have too many expected participants and therefore the rally cannot safely proceed, or that your choice of location is not suitable for some reason, and you still want the rally to go ahead. A court process might result. So, as I just discussed, the exact procedure will depend on the timing of when you served the Form 1 on the police commissioner, but in any event, a court process might result. When the case comes to court, the court has to engage in a very difficult exercise in deciding whether or not to approve or authorize the assembly. There's no actual test in the legislation. There's nothing, the Parliament hasn't said what test judges are to apply in deciding whether or not to authorize or to prohibit a public assembly. But the way that the courts have interpreted, those tests is that the Act is attempting to strike a balance between different competing rights, including the right of us as citizens to exercise our freedom of speech and assembly, weighed against things like safety and public order. The court has to decide where in a particular case those rights lie and how to strike the balance between those different competing considerations. It's also possible that the court process might result in modifications being made to the assembly, for example, a change in the location or the route. And the police commissioner might also change their position during the court case. They might form the view that they are able to approve the assembly due to negotiations. The court does expect, like in any case, any court case, that the parties will attempt seriously to try and negotiate and try and resolve the case on their own terms, and expect the police in particular to have engaged in a serious attempt to negotiate the rally before it proceeds. So as we discussed, if the police don't wish the rally to proceed, but instead apply to the court to prohibit the rally because of the timing of the application, it's possible for the court to make an order prohibiting the assembly. I just want to pause here because there's an important case from 2025 that we need to talk about in this context. For the non-lawyers that are in the meeting, in Australia we have different sources of law. The main source is obviously legislation. Another source is the Constitution that I spoke about before in the context of the implied freedom. And then another source of law, again, is also cases decided by judges. So judges have a role in interpreting laws, and in doing so, they can create law. If a rally is prohibited by a court, a recent case from 2025 suggests that that can have consequences for people attending that rally because they are attending a rally that has been prohibited by a court order. So if you go through the court process and the court ultimately decides that the rally shouldn't go ahead for whatever reason, and they make an order prohibiting the assembly, the court has suggested that that could raise an issue in relation to what's called contempt of court. So contempt of court is something that happens when you disobey or show disrespect to a court, including when you disobey a court order. In this case, the court suggested that knowingly attending a public assembly where you know that it has been prohibited by a court order may raise a question as to whether you are engaging in contempt of court in attending that assembly. Just to give a little bit of context, this case was about a Palestine protest, which was to take place on the forecourt of the Sydney Opera House. It was ultimately prohibited on consideration of matters including the expected number of attendees and the capacity of the forecourt to accommodate that number of expected participants. But in the course of deciding that case, the judges sort of went on to consider what would happen to someone who might knowingly attend assembly, which has been prohibited by court order. And it's in that context where the court has suggested that knowingly attending a protest that's been prohibited may involve a contempt of court. We consider this to be a very significant change in the law and the very first time that this proposition of law has arisen in the very many years that the Summary Offences Act has been litigated and has come before the court. For many years, it has never been the position of the police or of the judges deciding these cases that a consequence of attending an assembly that has been prohibited is that participants in that assembly are potentially exposed to criminal or civil liability for contempt of court for attending that assembly. This could have obviously consequences for people attending if they are charged with an offence for contempt of court, for example. And we're concerned that this decision could have, or this approach to the Summary Offences Act could have stifling consequences because it may provide consequences for people that attend a protest. As my interpretation of the case law up until 2025 is that the primary position of the police and of the judges of the Supreme Court was that even though it was referred to as a prohibition order, that did not mean prohibition in terms. Rather, it just meant that people attending the assembly would not have the benefit of the protection of that immunity provision that I went through before, rather than creating any potential liability for contempt of court for attending the assembly without authorization and in contravention of a prohibition order. We do suggest that this the court decision by the Court of Appeal in this case is a threat to democratic rights in New South Wales, and we are concerned about this. We're not aware of anyone who has of any public media coverage indicating that anyone's been charged with contempt of court for or aware of this situation arising. But that said, we are still concerned about it and are considering it. So I've spent some time powering through the Form 1 procedure and just briefly describing that to you. And for the purposes of today's discussion, all you need to really remember is that that process exists and it's important and that you should strongly consider doing it if you are wishing to hold a public assembly in New South Wales. But I also need to discuss the criminal law. And part of that is the Crimes Act in New South Wales creates an offence for attending what it calls an unlawful assembly. This is a different concept to what we've been discussing in the context of the Summary Offences Act, which talks about public assemblies that have been authorised under that legislation. This is about what the Crimes Act refers to as an unlawful assembly, which is a very different concept and has quite a few requirements. You can see there that it requires 5 or more people acting in an assembly with a common object of, by means of intimidation or injury, compelling any person to do what they're not legally bound to do or abstain from doing what they're legally entitled to do. So this is quite different to, what we would consider when we think of a peaceful or a non-violent assembly, as it requires intimidation or injury. And yes, so all that is to note is that there is an offence for certain types of assemblies, and an authorised public assembly could hypothetically, or any protests could hypothetically become an unlawful assembly under this provision if it involves participants engaging in conduct that is able to be, shown to be involving intimidation or injury for the purposes of compelling other people. So that's the first thing to note about the criminal law. There's an unlawful assembly offence, and it's quite different to a regular peaceful protest. The other thing to remember is obviously the criminal law, the general criminal law. So most criminal offences continue to apply at all times, as they do generally in society. And there are a few different categories of offences that are commonly seen or charged at protests in New South Wales. We've highlighted some of those on the slide. So one of those is obstructing or hindering the police. This can be a contentious offence, particularly where the police might have engaged in a forceful manner in policing a protest, and someone has resisted or reacted to that police behaviour or conduct. Assaulting the police. Again, this can arise where the police are, implementing force to police an assembly through, for example, using crowd control tactics, and a person's reacted to that. Offensive language or behavior. So this can apply to anyone at an assembly who engages in offensive language or behavior, which again is also a very contentious category of offence. There are also other offences that apply, such as vilification and hate speech offences, prohibited symbol offences, Nazi-related offences, as well as offences that relate to things like property damage, for example, lock-ons that cause property damage or graffiti. And then there's also offences that apply to different types of lands where protests might occur, such as on enclosed lands or sort of private or quasi-private lands, as well as forestry, mining, and maritime offences. So all of that is to say is there's a wide range of criminal laws that can be deployed at a protest and relied upon by the police. That can be controversial, and that can also, in certain contexts, hinder or restrict the ability of people to participate in a protest, particularly if the policing response to, for example, someone engaging in an offence, that person is potentially only one part of a much larger assembly, and their conduct in engaging in that offence shouldn't be relied upon by the police as a reason or a rationale to conduct the assembly generally, because not necessarily everyone at the assembly is behaving in that way. Another thing to note is, again, now speaking more about the role of the police at protests, police have many powers. And police are a visible presence in society. They have a monopoly on the use of force, and they're in a special position because of that monopoly. The law authorizes them to use some force to do their jobs, but it doesn't let them use unauthorized or unreasonable or unlimited force. It only authorizes police to use force where there's a legal authorization for doing so, and the amount of force is reasonably necessary for the purposes of exercising that lawful power. So there's a number of things that the police will have to demonstrate if they have used force. They'll have to show why they used force, and that the amount of force was proportionate to the threat or to the reason that the force was used. That's going to involve a consideration of every conceivable factor, including the conduct of the person, who was the subject of force, threats to the police or other members of the public, the age, gender, size, number of people, and any resistance being offered to, police, lawful police directions or exercises of power. However, one thing and an important thing to note is that the police do not have a general legislative power to forcefully break up a peaceful protests in the absence of a lawful reason. Police also have the power to issue move-on directions. And move-on directions are basically a direction that someone leaves an area. Um, in the context of public assemblies, there are some limitations about the types of move-on directions that the police can give, which differ to the powers that are available at other times in society that don't involve protests. The text of that exception is on the slide, but basically the only circumstances in which the police can move on participants in a assembly, whether it's authorized or not, is to deal with a serious safety risk to that person or any other person, and also where the assembly is causing an obstruction to traffic, and that's not authorized because it's an unauthorized assembly, or if the assembly is authorized, the obstruction goes beyond what was intended or proposed in the assembly. So, for example, if you have an authorized assembly to go from Hyde Park to Central Station, and that's the extent of the authorization, and then you try and continue the procession up Parramatta Road, towards Western Sydney, that is not authorized, and the police would have the power to move you on in that circumstance. So now that we've spoken very briefly about the role of the police at protests, which we'll return to towards the end of this discussion, we also wanted to talk about recent laws in New South Wales that have limited or cut down or curtailed the right to protest. Most significant of those to note is the Public Assembly Restriction Declaration. In December 2025, following the terrorist attack in Bondi, the government introduced amendments to terrorism and other legislation, which with extraordinary speed, which a court has since found were constitutionally invalid to the extent that they restricted public assemblies. The amendments were made which permitted the police to issue what was called a Public Assembly Restriction Declaration, which, after a declared terrorist incident, basically disapplied the public assembly process that we were discussing before under the Summary Offences Act. It made all public assemblies, it essentially made it not possible for that procedure to occur, and all the public assemblies in the area covered by the PARD unauthorized and incapable of being authorized. So, to simplify, these laws gave the Commissioner of Police power to make a declaration that an area is an area in which no protests could or assemblies could be approved. And once such a declaration was made, that was it. The police also had additional powers to move on people who were at a public assembly in those areas. So additional to move on, the more limited move on directions that I was just discussing with you. These declarations were obviously made in the context of the recent terrorist incident, but also in the context of many rallies and protests particularly in support of Palestine, and in relation to the Middle East since October 2023. A news article from the SBS in September 2025 indicates that some 900 rallies in support of Palestine had occurred since October 2023 in Australia. When the law was being passed, the minister's second reading speech said that a reason that these laws had been passed was to protect the community and enhance social cohesion in the wake of these terrorist acts by placing sensible limits on the authorization of public assemblies. It was therefore explicit in that parliamentary rationale that the public needed to be protected from public assemblies that would otherwise be allowed to proceed under law, and that this was also necessary to protect what the Parliament referred to as social cohesion. You can see on the slide the coverage of the first declaration, which was essentially all of metropolitan Sydney. As a result of a decision called Jarrett, the Court of Appeal invalidated those laws, on the basis that they infringed the implied freedom of political communication. The court looked at whether the laws effectively burdened in political communication, and also whether they lacked a purpose or had a purpose which was compatible with the Constitution, and if so, whether the laws were disproportionate in pursuing that purpose. The Court of Appeal, in their judgment, said that the laws did pursue an illegitimate and unlawful purpose, so far as they sought to ban public assemblies altogether in the name of social cohesion, which the court noted would also ban assemblies even in support of the Parliament's conceptualisation of social cohesion. This was quite a notable feature of the case, as it's quite rare for a court to find that a government has pursued a constitutionally illegitimate purpose when making a law. Usually, implied freedom cases will rise or fall on the question of proportionality, not whether the law pursues a legitimate purpose. However, the court also said that not only did the laws pursue an unconstitutional purpose and an illegitimate object, but they were also disproportionate in pursuing that purpose by banning all assemblies. The court, in the context of commenting on the purpose that was being pursued by the laws, said that laws which are intended to restrict and discourage public assemblies to protect social cohesion by avoiding divisiveness and perceived divisiveness and disharmony is not a legitimate purpose. It said the system of representative and responsible government entrenched by the Constitution, involving a free and true choice by the electors, entails acceptance of the potential for disharmony, incivility, and disruption that is part and parcel of democratic intercourse. That is reflected in the long-standing recognition that the protection of dissent is at the heart of the implied freedom. So the court didn't accept, in doing so, arguments by the state of New South Wales that the laws were justified by the need to promote what it called social cohesion by stopping protests that might offend or upset people, even at a time of potentially high tension in the community. The court said that that's not a legitimate purpose because people in Australia are free to express political views, and that might involve conflict, disagreement, and some level of disruption. Moving on from Jarrett, the other law that we've seen recently used by the New South Wales government to curtail protests is the Major Events Act. Now, you might be wondering how an act called the Major Events Act could be used to restrict protest, and that is a good question. The Major Events Act allows the New South Wales government to declare a major event. It's over a particular area for a set period of time. It's usually used for sporting or cultural events. Previous major events have included the 2023 Women's FIFA World Cup and the Men's T20 World Cup. To our knowledge, and I think knowledge of the court, Major Events Act has not been used in connection with a protest before. And the Act also specifically prohibits using that Act to declare an industrial or political demonstration or protest to be a major event. The significance of a declaration under this Act is that it gives the police some additional powers for the area covered by it, and including some additional crowd management powers, and also gives an immunity in narrow terms to people exercising powers under that Act. There was an unsuccessful challenge to the application of this law to the visit of the Israeli President Isaac Herzog in February of this year. In that case, the protest organisers, among other things, noted that the Act isn't meant to be used to regulate industrial or political demonstration or protests. The way the judge reasoned on that issue was that it wasn't any protests or public assemblies that were being regulated by the Act, but rather the presidential visit itself. The distinction there is not obvious perhaps to everyone, but it was to the judge. But we do contend that that's a subversion of the Form 1 protest, of the Form 1 process, and this the result in that case was quite clearly contrary to the intended purpose of the Act, which is not to be used to regulate public assemblies. We should note that the application or the usage of the Major Events Act to this particular assembly in February 2026, on the 9th of February, may be challenged, and it may come up again in the context of those persons who were charged with offences under that legislation. Um, the final point, and I realize I'm covering a lot of content, so thanks for your patience, is to just again talk about the police. You might have noticed we started the presentation with a photograph of the New South Wales Police, and we've returned to another photograph of the New South Wales Police. That's because the police, that we say, are a really important function of any protest. They are the interface between and a literal embodiment of the state. And that's something that international law recognizes and regulates, that the role of police at protests is to facilitate rather than to intimidate or stop protests. The level of permission given by the state or by a government to a protest can affect the conduct of the protest and the safety of participants. We've obviously seen that in the past, in 1978 with the Mardi Gras rally and the force that was used by the police there. And we've also seen it more recently with allegations of excessive force by the police on the 9th of February in breaking up the protests there. In this context, we also want to note that police, particularly the Public Order and Riot Squad in New South Wales, have increasing options for lethal and less lethal force, including OC spray, tasers, firearms, as well as using crowd management tactics such as kettling, which is a tactic that the police denies that they use, but involves marshalling or moving people to a particular area, and many say the police do in fact use. New South Wales Police have also been known to, for example, bring ultrasonic sound cannons, or what's called a long-range acoustic device. Some people would say that that's a type of acoustic weapon, given that it can emit frequencies and sounds so loud that they can cause permanent hearing and traumatic brain damage. And that's the position of the peak audiology body in Australia. However, the police maintain that the usage of that, or the presence of that at protests, but not its usage, is an appropriate deterrent at protests, and that they may wish to use it for crowd control purposes. We also wanted to note recent news coverage and indications by the government that the government may be making police officers available at public assemblies and protests with long arm rifles. We would express some concern about the presence of highly militarized police officers at peaceful protests in New South Wales. This has a chilling effect, and that's something that United Nations guidance speaks about when it talks about the role of police at public assemblies. I've extracted there from a manual or guidance published by the United Nations, which notes that the use of weapons to disperse a peaceful and otherwise peaceful assembly is obviously unlawful, but also the presence of heavy displays of equipment, whether they're lethal or not, can escalate tensions during assemblies and chill participation in that assembly. So in conclusion, and I'm leaving a few minutes for questions if there are any, we just wanted to emphasize a few things today. The first is that there is laws in New South Wales. There's a Form 1 procedure, and you should engage with that. Whatever view you may have about that procedure, we recommend you engage with that if you wish to hold an authorised assembly, particularly if you're intending to hold a large one. We've also seen other laws, including terrorism and major events legislation, being used by the state to restrict the right to protest. And we've also seen that Australian parliaments, not just the New South Wales Parliament, but other Australian parliaments and executive governments, will sometimes go too far in banning or regulating protests, and Australian courts will strike down that legislation where the balance isn't struck appropriately. We've also suggested that if international law applied directly in New South Wales in full, particularly the ICCPR, we would see some criticisms of the laws on that basis and some issues around compatibility. To that end, we just wanted to close to note that one of the very many issues before the United Nations Universal Periodic Review, which is a way in which states' compliance with international human rights and other obligations is assessed, there were many submissions made about Australia's track record in regulating protests in Australia, whether that's through the use of the criminal law or through other means. And there were numerous submissions to that point, and we would encourage anyone interested in this topic to read those submissions. So that said, that's our presentation, and we've left our details on the slide. And I'll now just check the questions box.
Thanks, Ryan. That's amazing timing, covering a whole lot of ground there. So thank you very much. Thanks to Larissa, who posted in the chat that there's been some scholarly criticism about the research that I mentioned about the 3.5. So good to have some debate already happening in the chat. So now, as Ryan said, it's time for questions. Please post any questions if you want into the Q&A or the chat room. So any questions, please post them now. Maybe while we're waiting, Ryan, I'll have a question for you. So what do you think is the next sort of challenge in terms of protesting laws, particularly in New South Wales, in terms of where it may head with case law and legislation?
Two responses to that. The first will be to see how this issue about contempt of court plays out, and for any future assemblies that may be prohibited. That would, if anyone, for example, is charged with attending an assembly that's been prohibited, that would be a very interesting vehicle to challenge the court's decision in that case, or the court's suggestion in that case that that doing so is a contempt of court. The other aspect is also in relation to legislation passed by the New South Wales government. So there was some proposal, in particular earlier this year, by in political in Parliament and by members of government, that particular forms of political communication, particular phrases, or might be restricted. The latest indication from the government is that that legislation will no longer proceed. But we sort of need to remain vigilant and watchful, because there may be future attempts to sort of to regulate particular forms of expression and particular wording used, or phrases, or yeah. So I think those are the two areas to watch at the moment.
Yeah. Thanks so much. Look, we don't have any questions. I think you answered them all, Ryan. We have one comment said from Marion, excellent presentation. Thank you so much for explaining these areas of law so clearly. So thank you everyone for joining. This will be able to be, that's been recorded, and we'll be able to send it out to those who participate in the webinar and those who put their names down as well, and probably on our social media. Thanks very much and have a good day.